To successfully defend against a negligence suit, the defendant will try to negate one of the elements of the plaintiff's cause of action. In other words, the defendant introduces evidence that he or she did not owe a duty to the plaintiff, exercise reasonable care, did not cause the plaintiff damages, and so forth. The first kind of negligence that can be used as a defense is contributory negligence, one of the most common uses. It occurs when a plaintiff's conduct falls between a certain standard necessary for the plaintiff's protection, and this conduct cooperates with the defendant's negligence in causing harm. In plain English, this means the plaintiff most likely would have avoided injuries if he or she had not been negligent. Another kind of negligence is comparative negligence, which comes in three types. Pure, when a plaintiff is awarded a percentage of the damages for which the defendant is responsible. 2, modified, when a plaintiff is awarded damages only if he or her negligence is equal or less than the defendant's negligence. Or 3, slight gross. The plaintiff is awarded damages only if his or her negligence is considered slight and the defendant's negligence is gross. For example, a drunk driver strikes and seriously injures a pedestrian who failed to use a nearby crosswalk. Although it's unlikely the driver would have acted any differently had the pedestrian used the crosswalk, the driver's civil liability may be reduced due to the plaintiff's own negligence. Finally, there is an assumption of risk, which is when a plaintiff assumes the risk involved in an obviously dangerous activity but proceeds to engage in the activity anyway. He or she may not be able to recover from damages for this injury. Either one of these defenses are ones that were used by McDonald's in order to argue that it was in fact Liebeck's fault and not their coffee's fault that she experienced these burns. While Stella Liebeck did face real injuries from her coffee spill, compensation of over $2 million, or what we can assume she received from McDonald's, could seem to some as excessive. In this case, the combination of attorney fees, medical bills, and mental distress that the plaintiff experienced seems reasonable to be compensated by $2 million. However, there have been other reported cases in U.S. history of frivolous lawsuits. One of the most infamous cases of a frivolous lawsuit is known as Pearson v. Chung, or the Pants lawsuit. Roy L. Pearson, Jr., who at the time was an administrative judge in the District of Columbia in the United States, following a dispute with his dry cleaners over a lost pair of trousers, filed a lawsuit against the owners, initially demanding for $67 million of inconvenience, mental anguish, and attorney's fees for representing himself as a result of their failure, in Pearson's opinion, to live up to a, quote, satisfaction guaranteed sign that was displayed in the store. The case drew international attention when it went to trial in 2007. Pearson, as I stated before, defended himself in court and broke down in frustration in his own questioning over how much distress the lost pants gave him. In the end, the court ruled in favor of the cleaners and awarded them the money equal to that of their lawyer fees. However, their lives were never the same after experiencing such a traumatic court case. Many people have argued that the United States legal system allows for too many frivolous lawsuits. For example, this British analyst is highlighting how ridiculous some of these claims can be, such as a surfer suing another surfer for stealing his wave, and other examples like this. Other countries across the world can find these lawsuits quite ridiculous, but in the United States it's a topic of large discussion. People find that people waste thousands of dollars each year suing for causes that aren't worthy. However, the debate comes that if we start making restrictions on when one can and cannot file for a lawsuit, that those truly needing compensation for an injury or something like that won't get the help they needed, which is why this reform has never been put into action.
Anyone can sue anybody over any frivolous thing. One of my favorites is a lady who witnessed a traffic accident and sued for the loss of her psychic powers and got $500,000 from a jury. And that kind of thing happens every day in America. It's disgusting. It doesn't happen anywhere else but here. Yeah, that really happened. There was someone also, someone sued someone else for one surfer sued another for stealing their wave. Mm-hmm.
Okay. Okay.
And don't get me started on prisoner petitions.
Okay.
Yeah, there's a book called "Buy This Book or We'll Sue You," which
That's funny, yeah.
talks about some of these things.